Hello, and thank you for joining us today, both everyone here in the room. It's fantastic to see you, alums, distinguished members of the bench and bar, graduates, current students, faculty and staff. Fantastic to see you all here, and great to have a nice group online as well in our new and digital world. It's good to be in person and it's good to be accessible, and we do both. Since 2014, one of the defining annual events at Arizona Law has been the Peter Chase Neumann Civil Justice Lecture, a foundational element of our broad civil justice initiative. Every year, the goal of the Neumann Lecture is to explore the power of the law to advance justice for individuals, for communities, and for our country through the civil justice system. This year, it is our distinct honor to celebrate two lawyers, both extraordinary advocates, both highly regarded in the profession and their communities, and both Arizona Law graduates. Their long and productive legal careers embody the goals of a just, dynamic, and effective civil justice system. First alumnus we celebrate today is, of course, Peter Neumann. It is his generosity that created this lecture series. Peter graduated from Arizona Law in 1964 and began his career as a criminal defense attorney, and then moved to the Pima County Attorney's Office. In 1968, Peter moved to Reno, where he maintained a prominent civil plaintiffs practice for many years. He became an active participant and leader in the Reno community and in the state of Nevada. Last night, he was observing that when he moved to Reno, there were 50,000 people in the community, and there are now something north of 500,000. So he's been there to see the transformation of the biggest small town in the world or the smallest big town in the world. I can never remember quite which. In the early 1970s, he was one of the first Nevada lawyers to win multi-million-dollar damage verdicts for a client. Over his distinguished career, Peter's represented victims in air crashes, defective consumer product cases, including a number of famous cases against the AMC Jeep CJ5 for its proclivity to roll over and harm its passengers. Also handled a number of insurance bad faith cases. And like so many plaintiffs lawyers, and like so many lawyers, and this to me is a point of pride for our profession, Peter's interests have extended to politics and to public policy. His passion for the pursuit of justice includes broad concerns for the protection of civil rights. On a more personal level, and since he represented clients in air crash cases, this is pretty important and interesting point. He's been flying planes, both with and without engines, for many years. He flew himself here to Tucson from Reno. That plane has engines. Peter, please stand as we recognize you for your incredible contribution to the law and to our college. Next, I am delighted to introduce the second alumnus we are celebrating today, this year's Neumann Lecturer, James Jimmy S. Rogers. I can't miss the obvious point that it's incredibly fortunate to be at a college with two distinguished alumni with the names James Rogers. Jimmy graduated from Arizona Law in 1972 and established his own law practice in 1986. Now he's the principal lawyer in the law offices of James S. Rogers in Seattle, Washington, of course, where he centers his practice on serious personal injury and product liability litigation. His work has garnered him many notable recognitions. Jimmy's been selected as one of the best lawyers in America every year since 2003, listed in Super Lawyers Top 100 for Washington for 10 consecutive years. His numerous selections as best lawyers, lawyer of the year in both plaintiffs' product liability litigation and personal injury litigation. And he is both a fellow and member of numerous organizations. We want to hear from him, so I'm not going to read and list them all. His career has been devoted to the pursuit of civil justice, been a powerful voice for those seeking redress through the civil justice system, in line with the purposes of this lecture and program. He's an inspiration to our students and to attorneys, and a model for future trial lawyers. I want to acknowledge his dedication to his alma mater, to our college. This is his third trip to Tucson in just the past year. Last fall, he joined us to celebrate his 50-year law school reunion. And in May, he received the Law College Association Award during commencement. Jimmy's talk, Passion and Justice, a lifelong journey through trial law, will provide his perspective on the evolution of civil litigation through the lens of his decades of experience, as well as thoughts on the importance of values and belief systems in the practice of law. We hope you will take questions at the end. Please join me in welcoming this year's Neumann lecturer, Jimmy Roth.
So nice. Thank you, Dean Miller, for that wonderful introduction. It's such an honor to be here today giving the Peter Chase Neumann lecture with Peter Chase Neumann sitting right there. I've known Peter for many years. I have the highest regard for him. And I will do his lecture today, justice, I hope, and continuing the tradition, the enlightening nature of it, and the inspiration that your lectures have brought in the past years. Thank you. Thank you for having me. It's my honor to be at this wonderful law school that I was so proud to be an alumnus of. And I thank you, Dean Miller, for reminding me how long ago it was. Because I had forgotten, because it seems like yesterday that I was here, I was walking the halls, and it's just been a pleasure for me. My topic is a lifelong journey through trial law, through my career. And it's an exciting topic. I do personal injury law. I have a focus, and have always had it, on product liability. And in the product liability arena, on automotive product liability has been a sub-focus of my work. And that's what I'm going to talk about today, and also the rule of law. The rule of law is integral to all we do. It's the legal principles that should guide us and do guide us as a society, a civilized society, and I will refer to it throughout my lecture. And I welcome questions. You can wait on those a little bit, but at the end from you, I would love to hear them. But first, since this is my journey, I'm going to talk about a few things, a little peripheral to the practice of law, but kind of connected. I read Louis Neiser's My Life in Court in 7th grade. And that's when I decided I wanted to become a trial lawyer. And I never lost that desire. I graduated law school, and before I started practicing law, I applied. Here's the rule of law. I applied to the Neighborhood Playhouse School of Theater in New York City. And it was a very, very well-known school of theater. Sandy Meisner was the director, one of the great theater directors. And I was shocked to get accepted. I interviewed for it in San Francisco. And this is a school where, Diane Keaton and Dustin Hoffman and Gregory Peck and Joanne Woodward, they all went. And this was really exciting for me. I didn't go. I instead started at the same time practicing law, but I have to share with all of you that there have been moments in my life when I've thought, what if I had gone to the Neighborhood Playhouse? But so I'm sharing that today. Nobody knows I've had those thoughts. I started working in Seattle with a very well-known lawyer, Lem Howell. And I worked in his practice of plaintiff's personal injury. That's when I first knew what I wanted to do. And police misconduct cases, which Lem did. Another diversion, then I'll get into my career more. In 1981, there was a new program called Morning Edition on NPR. And for a year, once a month, I did commentary with the then host Bob Edwards on legal issues. And it was a terrific experience, again, tangential to what was my practice. We talked about the penthouse libel trial in LA, the slavery trial in North Carolina, the duty of a city to house its homeless in New York, the creation science trial in Arkansas. I did research for all of that, and it was fun. So then I got really into my practice, and I realized this is what I love. I love tort litigation, trial work. This was my thing. Yes, trial does have analogies to theater, so I got that part of me a little bit satisfied. And I got into doing that, and then after a decade, I did what all driven trial lawyers do. I wrote a musical. Now, just the book and the lyrics, because the music was by Cole Porter, George Gershwin, Rodgers and Hart, and other purveyors of the American songbook. But it was performed by some of the best equity musical actors and performers in Seattle. It was great. It was performed twice, once before the National Convention of ATLA, which was the Association of Trial Lawyers of America. It's now AAJ. And the second time 2 years later before the Seattle King County Bar Association. Back to my practice. One of the most satisfying parts of doing automotive product litigation for me has been to see over the years the changes made by automakers to the vehicles, in part due to the work that those of us who have done these litigation automotive product liability cases have done. Crashworthiness is the name of is what we do. And crashworthiness is, what it means is, it's the injuries a person receives in a crash that the person would not have received had there not been a defect. It's called enhanced injury. It's the injuries over and above what the injuries would have been. And this is where I've spent a lot of time, and want to talk to you about a few of the cases I've had, the defects. The first cases, before I had them, where crashworthiness started in 1968 with a seminal case of Larson v. General Motors. And then in the late 70s and 80s, there was, and I'm looking right at Peter Chase Neumann, the CJ5 and CJ7 rollover litigation that he was very involved in. And what that was there were these vehicles that were Jeeps, and they were unstable because they had a narrow track width and a high center of gravity, and they rolled over, and they caused serious injuries and death to people who otherwise would have maybe not been injured or had minor injuries, the principle of enhanced injury and crashworthiness. These were followed by the Bronco 2, the Samurai, the Trooper, also rollover cases, defects. And one of the aspects of crashworthiness litigation that I still don't understand is how automakers keep making and generating the same vehicles with the same instability, even when they've had lawsuits, they realize there's a problem. We got a problem here. They keep doing it, and that's been something, I guess, a commentary on them in a sense. Grimshaw v. Ford Motor Company was the next big case, seminal case, 1978 verdict. It was a case, this is not from that case, but this is the defect, and I'm going to show it to you. It said there was a gas tank, and a lot of you may know some of this already, aft of the rear axle. That's where it was located, and I did this. This was the red. This was not the vehicle in Grimshaw. It's a different vehicle, one of our cases. And in a rear-end collision, the striking car hits the gas tank, and it explodes, and there's a death. And it was Mrs. Gray who was driving, I recall, and she was killed because the car exploded. And this was a Ford Pinto, and it was the famous Ford Pinto case. Well, automakers from 1986 all the way through 2004 kept making cars with this defect. Many were shifting over time to put it in the midshift or the center of the vehicle so there wouldn't be any issue when there was a rear end. But there were cases after case with vehicles hitting the rear of the car, boom, explosion and death, enhanced injuries that would not otherwise have happened. And finally, by 2004, and we have a case now like that, they stopped. They still made them, but not much. The next area to talk about is airbags. and I'm only picking one of the many. And airbags came into play were really in 1986 is when they became on the market, when they were kind of the NHTSA, they were approved. And before that, you weren't really seeing them. I mean, there were some of the demonstrations in the 70s. When airbags first came out, many of you recall that, it was a problem with them. I mean, they were always great, and all of these the safety devices, when they're done, are great. But when there was a frontal impact, the initial airbags for some years deployed very aggressively and very fast, and they injured and killed people. And I know they're for safety, they're supposed to cushion the impact. I had a case in Central Washington where an 18-year-old woman went through an intersection. That's all she was doing, had a frontal impact, airbag deployed so aggressively it killed her. And it was in 1998, 1999, when they were finally depowered by the federal government. But those were the early airbag cases, and there were many of those. And they kept on being made. And I always wondered if it was when the federal government finally ordered them deployed or ordered them, to be cut back, because they weren't stopping. Now there are airbag cases, and there have been for some years, and we've been quite involved in that. And airbag cases now mainly are for the late deployment or partial deployment. And what that means is, and there's been a lot of these cases, and they still are existing. And again, cars have gotten safer, and there's defects less, but they're still there. And that's why I'm addressing you on this. You're in the car and you have a frontal impact. These are frontal airbags. And the airbag doesn't go off until late. It's delayed. It goes off too late, and the occupant, he or she, goes right into the dash or into the steering wheel, suffering serious injuries or death. And those are still continuing. Again, a lot of the vehicles have had repetitive injuries, and they're still being made, but they're better. And there's some times where there's partial deployment and you're still severely injured. There was also, as many of you know and recall, the Takata airbag cases where the airbags would deploy and it would explode, causing, again, serious injuries or death. I feel like I'm instructing you. Let's say, which crashworthiness cases, if they didn't have those deployments, everybody would be okay or not injured. And to make it worse, a lot of the, as you remember, staccato airbag cases had shrapnel shooting out of it, which hit the occupants in the car and was very serious. Airbag, again, are as a very good safety device when they work properly. The other thing I want to talk about is sudden unintended acceleration. We call it SUA. And that's when you're either stopped and you start up your car, or you're stopped even in an intersection or a light, and you start up a car and it shoots ahead like the California Screamin' ride used to be at Disneyland, where it went boom, except that one was safer. And unfortunately, there's been a lot of deaths and injuries. A lot of automakers had some unintended acceleration. They haven't gone away. It's gotten better. Toyota had most of them, many of them, we thought, and I was involved in that. And we saw this again over and over happening. It's a tough defect. But the automaker that had the most complaints about sudden unintended acceleration has been Tesla. And, and they've denied, they're very on crashworthiness auto product. They're starting to try their first auto product cases now. And they don't settle them. At least they haven't so far. The final auto product defect I want to talk about and choosing them, and it's really hard because I could spend time talking about all of these, is what we've done in our firm the most of. And that's roof crush cases. Roof crush. And by the way, before we get to that, you see where it says FMVSS 216. I do want to talk about, and I hope this is useful to people, Federal Motor Vehicle Safety Standard. And that you have to meet the Federal Motor Vehicle Safety Standard, as Peter knows, in order to have a car sold in this country. The automakers, one of their main defenses has always been and still is, we met the standard, forwards, and we're safe. And juries have bought that. It's not true. I mean, they meet the standard, but meeting the standard does not make the car safe at all. The standard, all of them. This one's the roof crush one I want to talk about. Well, I can talk about it right now. This is being tested on each side of the roof with a heavy metal device. And if it's more than 3 times the weight of the vehicle, unloaded weight of the vehicle, it's considered not safe. All of them pass. It's very easy to pass. The problem is that passing it is meaningless because the fact is the car can be unsafe with not passing it. All of these lawsuits I've talked about, in every one of them, whether it's the airbags or sudden unintended acceleration or roof crush or a gas tank, they all pass there's federal motor vehicle safety standard. They have federal motor vehicle safety standards for all of these component parts of vehicles, and they all passed. Every car that's been recalled in the United States passed this federal motor vehicle safety standard. I mean, it doesn't have any relevancy. And this is what we argue in the court for, opposing their arguments. Here's from a case, one of our cases. This is a roof crush case to the belt line, down to where the window begins. And again, the injuries are catastrophic. This is quadriplegia, paraplegia. Well, quadriplegia you have death cases. And in these cases, there's something else that's important to talk about because it's called other similar incidents. And we are always amazed, like at roof crush. And I'll use a recent example. A couple of years ago, a colleague in Georgia had a trial against Ford. I'm not going to name the vehicles or anything else, but it was a roof crush case. And he introduced at trial 79 were admitted other roof crush cases with the same vehicle, which crashed. People injured or killed. And Ford kept making these vehicles. And over the years, they didn't change the roof at all. Things have changed now, they've changed since. But this is what happens. You see, that's the bad part. It's not just your case, it's all of the cases that are similar. So that kind of gives you a definition of crashworthiness. Today, in this day and age, there's a new kind of automotive product liability case. And that is collision avoidance technology. Many of you have this in your cars already. It's not new. It was first developed in light trucks back in 2002 and 3 in some vehicles. Volvo had one. And then in 2010, 11, people don't, they started to be available. And what these are, well, first of all, here's the difference. Crashworthiness cases, the kind I've been talking to you about this today, those cases assume there's going to be a crash. And they want to prevent injuries from the crash. That's what we want to do, prevent the injuries from a crash. Here, collision avoidance technology, the goal is to prevent the crash. And collision warnings, again, I'm sure some of you have that. There's forward collision warnings. You say a car is going in front of you and you see, here's something you don't want to hit. Lights will go on, beeper will go on, audible and visual warnings come on, and you apply the brake. You're about to enter another lane you don't intend to enter. You're going straight ahead and you start to swerve into the other lane. We've all done that. Lane departure warnings come on. You'll hear the beeper. You'll see colors. You'll see flashing. The blind spot warning, most of us know, a lot of us have, where the lights go on in the rearview mirror. You're too close to the car next to you. Pedestrian warning. Pedestrian warning. Somebody behind you and you're backing out. These are all important. They're good things. And I'm going to tell you about the litigation in a minute and why it happens. Collision avoidance, same thing. You're about to hit a car in front of you. But the difference is it's not a warning, it brakes. The car brakes, not you. You're backing up and there's somebody walking behind you, the car brakes, it applies the brake. Lane change, same things. The first collision avoidance technology, and the only one that's required by the federal government, is electronic stability control, where you're driving ahead and to keep it under control, so you start to realize you could, you veer out of control. You want to stay in your lane. And here I have a diagram I did of this. You've got, without ESC, electronic stability control, you oversteer, you can go into the other lane, but with electronic stability control, you stay in your lane. And that's a very important part of collision avoidance technology. What's the issue? What's the legal issue, Jimmy? What do you want to tell them about? Well, guess what it is? Most of these technologies, avoidance and warnings, have been around and they've been available. And the cases are, they should have been put into vehicles that people drive, that are accessible to everybody. They're not. They're put into the, it's changing, but they're put into the most expensive vehicles and the most expensive packages for this technology. Safety should be for everyone. People should not be in a position where they can't afford to be safe. And automakers know this, but this is exactly what's happened. They've been out of reach for a lot of people. And some of you know that from your own experience on them. What we've seen, and we're seeing more lawsuits now, because it's stunning how many, a friend right now, they have a light truck and they, it's been available, but somebody, you can't even afford it. What we're looking at here with the avoidance is something we all know about. It's part of the autonomous vehicles that we've talked about for years, that people have still said, we're light years away from, going out on Speedway and Grant and 22nd, shall I go through all the streets I recall? San Francisco, all of that. We're a long time away, not so far, because until Tuesday, on the streets of San Francisco, and a lot of you know this too, that in the last year, they've had fully autonomous vehicles available like an Uber or a Lyft, used as taxis. You call them like you would Uber or Lyft. And between 11 at night and 5 in the morning, they'd come and pick you up and take you around. Well, in the end of August 21st, the California regulators that control this gave the green light. They said, okay, San Francisco, and I know they're in Tucson, they're Phoenix and Austin, Texas, and LA has some of these vehicles, but not like that. You're 24/7 now. You can drive all the time. And that's been the experience. People, I haven't done it, but in San Francisco, any of you here want to go after the lecture and take a 24-hour, well, you can't completely do it, I'll tell you why, but take an autonomous vehicle of the future, you can do it now. And we thought the results have been good. Waymo is one of the companies doing it, and they're a subsidiary, they're owned by Google. And they've been one of the two companies. The other is Cruise, which is owned by General Motors. It's a subsidiary, actually, a subsidiary of General Motors. And this is the Cruise autonomous car in San Francisco. And by the way, I should tell you what this is all about. It's cameras. You see this on top of the vehicle. It's LiDAR, it's radar, it's sensors. That's what makes it do it. That's how it can that's how it can break and ultimately do everything. These cars have been running for 2 months, 24/7. And that's what we're looking at in the future. And then as I was preparing my talk on Tuesday, you know how we see the news on our phones. Cruise vehicles all pulled in San Francisco from the streets. And they were taken out of commission. So I'm here to tell you the latest update. You don't have to look at your phone. The cruises are out because there weren't that many, anything is serious if it's a crash, but there was a couple crashes with fire trucks, not Waymo, they're still there. There was one somebody that hit another car, pedestrian, and the car kept going and ran over him again, the cruise. There was some stalling. Dean Miller knows this, and they took him off. And they said, we'll be back. And GM has put in beyond millions into this. It's good technology, and it's a big step. So that's the autonomous vehicles and all of that. Let me go back to, besides crashworthiness, about accountability. Back to trial practice. In product liability, corporate and governmental accountability is very important. It's very important in this litigation. It's very important in our system. And jurors seem to be more responsive to accountability. And I think one of the reasons for that, and again, these are my impressions, this is through me today in my experience, is voir dire, picking juries. It's very important. It's always been important. I think it's even more important now. But voir dire is one of the reasons, and it should be a conversation between the juror and the lawyer, and you, the trial lawyer, and it should be about, with each juror, with judge permitting, the juror's belief systems and the rule of law. The trial lawyer should find out what those beliefs are, and should find out and discuss with each juror whether the juror will accept the rule of law that in a product liability case, they will hold corporations, governmental entities responsible, accepting the rule of law if the evidence justifies it. It's important. It's really key to find out if they will accept that rule of law, which is our rule of law in product liability. Trial lawyers should never, ever try to change a juror's belief systems that's been developed over the course of their entire lifetime in the 20, 30, 40, 60 minutes that we have for voir dire. In personal injury, death cases we do, lawyers have traditionally asked jurors for money, specific amounts of money during final argument. Well, that's evolving, it's changing. Now, experienced trial lawyers in catastrophic injury cases, for example, will ask jurors, they will tell jurors during voir dire, while they're talking with the juror, that they're going to ask for millions of dollars, or 6 or 7 or 8 figures. And if it will say, and if the evidence justifies it, will you accept coming back with a figure in that range? And that's important, because then you know the juror's feelings and you understand, and you're having a communication. And it's very important to do. And also sometimes we bring it up in opening statement, bring the amount, but talking with jurors in openings and voir dire is terrific. Elements of damages. Let me look at that. This is important. Jurors need to know what the elements of damages are. And every state has their own. We have 30.01.01 in Washington State, where I practice most of my work. And you just need to go over this, all of you, with the jurors, not to talk numbers or anything else, just to let them know during voir dire at this point what the elements of damages are. Because we have such an assumption sometimes they'll know and they don't, and they shouldn't have to know. It's past that we know, at past economic damages, past medical expenses, past wage loss, future wage loss, future medical expenses, future economic damages, and very importantly, non-economic damages. And that's the part that lawyers need to understand and be able to communicate to jurors. Nature and extent of the injury, pain and suffering, disability, disfigurement, all of those things, past and future. Jurors need to understand that this is what we're going to be asked to come back and find. Jurors are everything in our practice. And telling jurors and this isn't new in recent years, great lawyers have done it for many years, that they represent the conscience of the community, resonates with jurors and empowers them. Every jury is a reflection of the community in which the juror lives and works. Jurors take very seriously their responsibility as a juror, and they want to return a verdict that they can be proud of. Over the course of my career, and that is the topic, I guess, my evolution of trial law over my career, I've come to believe the public has become more safety conscious. I really have. People, oh, I gotta find this somewhere. There it is, thank you. People have developed reasonable expectations that products they use will be safe. And we need to understand that with cases we take and we try. In our jurisdiction, we have the consumer expectation test, and many, many states have it. And what that means is it's based on the reasonable expectations of jurors, of the ordinary juror, what an ordinary juror would expect. In our state, that's one of two tests for proving product liability. The other is risk utility test. But consumer expectations test is not used enough. And it should be, because the manufacturers, in their advertising, in their marketing, in their social media, they tell the juries what to expect. You've got it built in. And they have a hard time denying that. But they do. They have advertisements. Let me show you this. And in the advertisements, they have always made representations. Yes, the advertisements aren't as bold as they once were. Maybe litigation is part of that. This is 1956, everyone. You'll be safer in a 56 Ford. And then it goes on. You can't read the small print, but it tells why it's safe. I felt safe reading it. I mean, it's how can you not feel that way? Consumer expectations. A reasonable consumer would rely on the ad. And here's Toyota years later in 1992. And again, they've even toned down these ads some. When it comes to safety, we didn't overlook the small details. The small details are the kids belted in there. What they're really saying is, you put your kids in the car, they're gonna be safe. They're gonna be safe. Put them in this vehicle. Put them in this Toyota. And the next one is the Buick car, 1993. Safety is standard equipment. Wow, standard equipment. How are they going to go against that on the reasonable consumer test? The consumer expectations test. If it's standard equipment, any juror would reasonably expect to be safe, and they would ride in the car. It reminds me of Citizen Kane, great movie, when Orson Welles, Charles Foster Kane, was sitting with his wife, and they were having breakfast, and they were talking about his newspaper, The Inquirer. And she said, "Really, Charles, people will think," and he said, "what I tell them to think." And that's what the automakers are doing. They're telling them what to think in their ads. It's hard to get out of it. Throughout my journey, I have been inspired by great trial lawyers all throughout. And Paul Rivera is a Washington State trial lawyer who is one of the outstanding trial lawyers in the country and who has inspired me. And Paul and I have enjoyed reading autobiographies, and mainly biographies, of legendary trial lawyers, of great trial lawyers, by Clarence Darrow, who did the Scopes monkey trial in Tennessee. And he did the Leopold and Loeb murder case. We enjoyed reading biographies. people like Melvin Belli. And Melvin Belli was a San Francisco lawyer. I don't know how many of you remember Melvin Belli here, but he was called the king of torts. But his main contribution to our trial law is he was the person who really made demonstrative evidence available all over the country and the world in courtrooms. He brought demonstrative evidence, whether it was physical or illustrative, all of it. He brought that concept to the public. And Mo Levine. Mo Levine was an outstanding, brilliant trial lawyer from Long Island, Mineola, New York. He has books that are not that big. They were written in the 60s. They're as timely now as they were then. You should read them. Everybody here should read a Mo Levine book. In the book, Levera on Advocacy, that Paul Levera wrote with his wife Lita, they quoted an excerpt from a final argument that Mo Levine did in the case of Jenny O'Neill. And I just want to, if I may, take a couple minutes and just play a few minutes of that video. Mo Levine. Oh, it's me. How do I follow that? I've had heroes, continuing with the topic of my talk, my lecture. I've had heroes both in law and outside of law my whole career. Although David Bowie sung, "We can be heroes just for one day." My heroes have lasted my whole life. One of my heroes, I'll talk about two. One of my heroes was Justice William O. Douglas of the Supreme Court of the United States. What a man, what a justice. I liked his sensibility. When I went to law school in the late 60s, early 70s, we could relate to him. And he was a whole different generation. He was great. He was a dedicated conservationist, and he was an advocate for individual rights. Justice Douglas grew up in Yakima, Washington. He went to college at Whitman College, where my daughters, Zoe and Sabina, went. And when I was a first-year law student at the University of Arizona, right here, one of the biggest days of my life that year, thrilling, was when Justice Douglas came to speak to our law school. And he spoke because our esteemed Dean, Charles Ayres, invited him to speak, and Justice Douglas had Charles Ayres as his law clerk. So he accepted. And he came and gave just a thrilling address for an hour. It was a packed auditorium. At the end, he took questions and answers. And I have to say this because I think anybody there that day would remember it. Someone raised a hand, asked a question, and it was a really long question. And it went on and on and on. And we were all like, oh my God. And it was about the Saucony vacuum case, which is the antitrust case that held price fixing illegal per se. And it's one of the most, famous antitrust cases. Justice Douglas wrote the opinion, and footnote 59 is one of the most influential and famous footnotes in legal history that he wrote. And the student just kept going. And at the end, he paused and he go like this. And so, Justice Douglas, what did you mean by footnote 59? And Justice Douglas, with a twinkle in his eye, looked at the student and said, I don't recall the footnote. Next question. What a guy. Another influential person in my life was my uncle, David Teitelbaum. Rabbi Teitelbaum lived in San Francisco, down in Redwood City. In 1965, I forgot to have my picture. There it is, Justice Douglas. He flew to Alabama and to march across the Edmund Pettus Bridge with Martin Luther King for the voting rights of Black Americans. He wrote in his book, his memoir, As a Mighty Stream, The Life of an American Rabbi. And I'll quote you from some of it because I think it's important here today. He said, a feeling of great exuberance filled the air as we crossed the bridge. There must have been 10,000 of us, people of all races and creeds, and from all sections of the country. And they were all making this historic march. At the end, we came to a farm where there was a circus tent set up. And at one section inside the tent, there was a man who looked like Mr. King, Martin Luther King himself. I was startled to look into the eyes and the face of Martin Luther King. I introduced myself and I said where I was from. And he offered me his hand and he said, God bless you. Thank you for coming. That was a high point for me, Uncle Dave wrote. Let me speak to the law students who are here today a little bit, because I'm really in your area, your territory. Cases are the foundation of what we do in our practices. But there's so much more that can enrich our practices and our professional lives. Joining and becoming active in bar associations, law groups that are specific to particular areas of our practices, or pro bono legal activities enrich and add so much. They do to the practice of law. I presently serve on the Washington State Board of the Advisory Council now of the Endowment for Equal Justice, which is the largest civil aid endowment in the country. And it provides a source of sustainable funding for legal services for people who could not otherwise afford them. One of the very best things about being active in groups and associations is the friendships that I've formed over the years. It's invaluable, and it means a lot. My University of Arizona College of Law ties have continued with friends like Ted Schmidt of Tucson, former Peter Chase Neumann lecturer, Pat McGroder of Phoenix, and University of Arizona law professor emeritus, Robert Hershey. I met Bob Hershey my first day of law school. in the hall, and we've stayed close friends forever. And also Donnie Albert and Kim Richards, dear friends for life. So people ask me, Jimmy, what 2 words can you leave us with? I would say passion and justice. Passion has always motivated the work that I do. And I believe that passion gives you drive, and it gives you desire to be the very best lawyer you can be. Justice is what we work hard on behalf of our clients, all our clients, to attain. Justice is the fairness and impartiality that your clients are entitled to in the civil justice system that we are so very proud of in this country. Thank you very much.
Jimmy, thank you, and we do have some time for questions in person in the line, so yes.
You mentioned early in your talk that the automotive industry in particular has been very slow to react to some of the changes that have come or suggested by litigation. What do you think are some factors leading to that slow uptake when you think it would be to their benefit to adapt quicker?
Well, that's a good question. Should I repeat the question, or is that heard?
Might be helpful.
Okay, what are some of the factors in automakers responding slowly to the changes? I personally think it's, and having done this work for many, many years, that it's the nature of automakers. I think that it's a tough commentary when you see that it's lawsuits that finally have gotten them going on doing things safer. I think that's true. I don't know. It's not, if it was just the safety of people, they'd be made. So because I'm not in those boardrooms, I don't really know, but we have seen changes, and a lot of it is through litigation. That's just a fact.
And sorry, quickly to follow up, do you think it's particular of automotive makers, or is it in general?
No, I mean, generally, it's just general comments. I mean, everybody's different automakers are there. And like I said, vehicles over time, and I think a big part of litigation, have been made safer, but it's very hard to recognize, that they made a mistake. I think that's it too. They don't like to admit that something's wrong. I believe, but I can't speak for them because I'm not part of that group. Other questions? Donnie.
Hey, Jimmy, sort of a follow-up to that question. It always sounds like it would be a persuasive argument. You're telling me that it doesn't hold a lot of weight, that a manufacturer has followed the so-called minimum safety factors. All right, and I'm sure the defense brings that up in any of the cases that you have.
Many.
Why do you think, or do you think it would be helpful to get people within the plaintiffs industry to start trying to work with the regulators to increase their standards, so that what the goal is of everybody is that you have safe vehicles and safe other products on the road? They would be forced not through litigation, but actual regulation.
So you say that it would, and I'm repeating this because, we're repeating questions. Would it be in their best interest to work with regulators, or best interest to work with the consumer groups?
Why is consumer groups, plaintiffs' attorneys, and
Yes.
trying to work, or whatever groups can work with regulators to bring up their standards to the standards that you as a plaintiff's attorney think that the automotive maker should be following?
There's many opportunities for that. And the question is, why shouldn't the automakers work with plaintiff groups, consumer groups, to try to come together to find some standards and things that you can all agree on that they could be followed? On all of these standards, like the FMVSS standards, there are consumer groups involved. They're not always welcome at the table. They're not part of it. The automakers really do, and I can't speak for them, but pressing their interest. And economically, it's a big thing because their decisions are often, economically based and all of that. And So we don't see that, but there's been opportunities for that at the table because there are also consumer groups that are very involved in all these standards we're talking about. It's not just an automaker generated, although they do have, you know, a larger voice. So it's not, it just isn't always successful, and there's not always the openness to it. Questions?
Jimmy,
Ted,
so nice to have you here in Tucson.
thank you.
I wonder if you have any thoughts you'd like to share with the students that might aspire to be a trial lawyer like yourself in today's environment, you know, especially in the context of what a lot of us see as a vanishing jury trial. Do you have any thoughts or advice for the students on that?
Yeah, I mean, to be a trial lawyer,
Yeah, if I was in second or third year law student today, and I wanted to do what you and I have been doing for the last several decades, it's a much different environment. I mean, I tried 6 jury trials within the first year of practice. That's not available today for law students.
yes.
So how do they get where they want to go if they wanted to follow your path?
How do they get to be a really good trial lawyer? How can they move ahead given the environment today? That's a really good question. The reality is it's difficult. It's more difficult than we had it. And it's difficult because there are other things that exist like mediations that, you know, is now, we never heard of until 1985 when 2 Seattle lawyers started making it very popular all around the country. Most cases do that before trial. There is, you know, less jury trials because of that. There's also, you know, a focus on settlement, I think more, but the fact is it's a different environment than that. And one of the reasons could be, you know, the cost of jury trials and everything else. I think people have to know that it's exciting, that justice is wonderful, that juries are wonderful to be with, and, you know, people need to do it. And the environment is against that, or it's not against it, but, you know, they're just a vanishing jury, and I know all that. They just have to say this can be a good life. And I mean, not for them economically, but for their satisfaction of goals and feelings in their heart that they want to do. And most importantly, they can help people through that. And, you know, that's part of it. Again, the influences aren't that strong for it, but it's true that it's a great profession, and trial it's wonderful, and people need to try to do it, and they need to be encouraged by us, people like you and me, to do so. I hope a talk like this is helpful, but I don't know. We'll see. Thanks for the question. Bob?
Remember the 1955 words, that's the same era that doctors were recommending you smoke Camel cigarettes. So it seems to me, Jimmy, that the technologies have changed so greatly that lawyers doing product liability cases, certainly the self-driving vehicles, are going to have to know about computer technology, artificial intelligence, code writing. I think that, can you just speak a little bit to what the skills are necessary for product liability?
Really good question. Actually, it's a good point I didn't mention. With this new technology now, and with ultimately autonomous vehicles, and with collision avoidance, collision warning technology, it's a whole different set of expert witnesses. And it is different now because there's a lot of technical things, you know, a lot of people aren't. And what I'm saying is just more consultations with experts, more discovering people to help with that. I'm not seeing lawyers going out and, you know, going to school and, you know, getting educated to do that. But I am seeing bringing in new people and taking the time to learn about it. You have to do that. We all have to do that to be in this arena. And that's new. That's a good point. There's no other way to do it because the technology is here. And that's just, if you want to do this, and I think it's a terrific career, is that you should get that education. Yes, question.
Just the relationship that the attorney has with the client, just like to hear more about it from the plaintiff's attorney's perspective.
You're saying a plaintiff's attorney has with their client?
Yeah. Just if you could comment especially with your experience on the types of relationships that you have with clients, because I wager that they come from a wide variety of backgrounds.
Yes, they do.
And such. If you could just comment on that from your experience.
A good question. What relationship do plaintiff attorneys have with their client? Hopefully it's a very good one, because you're there to help the person, and they are the most important thing, the most important thing you're representing. It's not you, not the case, it's the client. So taking time to know the client, to be with the client, including your office staff, your lawyers you work with, is an important factor. It helps you with the case, but it helps them too. I mean, that's what you want. And I mentioned that. You want justice, but it's justice for the client, the individual client, and which benefits the whole system. So that's a commitment. That's true. And that's a time commitment that you do when you represent individual plaintiffs.
Is there any question?
You work with the insurance companies as you're doing one of these cases. For example, the insurance company of the person involved in the car, the manufacturing product that's being recalled through their insurance company? Or
I think the question is, do we work with the insurance companies? We
Yeah.
do. If it's, the more standard product, personal injury case, yes, you work with their carriers, but usually when you get the case, you file it, you communicate with them, and ultimately there's a lawsuit and you're working only with the lawyer because you can't talk to them after that. In the product cases, you do not work with the company like General Motors or any of those companies, and they have their in-house, they have the whole insurance section, but you deal with the lawyers that they have. So a lot of it is dealing with lawyers in this practice for the plaintiff. Different when you're obviously representing the person that's being sued, being the defendant.
Are there issues that you hope that students or professors or judges will understand better in your area, or things that you think they misunderstand sort of in a predictable way?
You're asking me what people should understand?
Do you think there are misunderstandings in terms of students or professors or judges about this area in terms of, what the law is, what the law should be, what's important in the cases?
It's a good question. Are people misunderstanding this area of the law, what the law is, what the law should be? Couple questions. It's really great to have a mentor and to have people who can advise you from early on. I was blessed to have mentors in my career, and you can talk with, you can get advice from. I read everything I could read, and I read books. That's very important. Now seminars, webinars, getting educated. It takes time. It takes drive, like I mentioned, and it takes a real commitment. But those are resources, and they're all there. They won't seek you out. You have to seek them out. And there's plenty of that, and it can lead to inspiration and dedication to doing this kind of work.
So this interesting question about how students, whether you're our BA students and you ultimately go to law school, or the JD students, follow this path. Ed's question, and Jimmy, your answer is a really interesting one. The lecture series, the Civil Justice Initiative, having torts is in the first year, it's not going anywhere. Professor Bublik would tell me it should still be 6 units. That's a different conversation. But it remains one of the cornerstones, and of course, civil procedure, right? So the combination that first year presents some of the foundations. And if and when students get excited, I think it's an enormous puzzle. We have these incredible lectures and alums. We have many who've worked in the area. You've heard the passion around the ability not only to represent clients, but to shape the world. But it is challenging. And one of the paths that many students follow is not to start on the civil side, but to go into the criminal justice system to prosecute or defend, because it remains one of the areas where you can get practice before juries, and trial, but to do it directly on the civil side, there are opportunities out there. But it's a really important question. I think we're doing a lot, Jimmy. I think your lecture today reinforces why this is a great and exciting area. My father in his career spent the last part of his career in a plaintiff's firm in Los Angeles and came to share all of these passions. But it's a natural and it's an important question. Gee, this is really intriguing. I'd like to help people seek justice. I want to do this work, and the answers are hard. But you've excited people all over again about the why, and that's important. And it's been a great day. Thank you so much. Again, I look around and see such a broad array of folks from our UA community, the law school, and the broader community here, as well as online. It's what we've hoped for these discussions each year. And it seems to me, Jimmy, your great lecture embodied that. So thank you.
Thank you so much. And thank you, Peter.